for either of those?
No.
On the 30th, did you test outside of the testing parameters?
Yes.
And did you also test positive for THC and amphetamine that day?
Yes.
Did you have a prescription for either of those?
No.
On the 3rd of December, did you test outside of the testing time period? Right. This is case number 254914SM, the people of the state of Michigan versus Candace Ann Kelly. Appearances, counsel.
Please sit all for the people.
James Dick on behalf of Ms. Kelly, Your Honor. She's sitting to my right.
All right. We are here for a couple different matters. One is a pretrial, and the other is an arraignment on a bench warrant. So we will handle. Actually, it looks like a second amended bench warrant, so we will handle
Before anyone jumps to conclusions, remember this is only the arraignment on the alleged bond violations, not a final verdict. The judge is laying out the accusations, and every answer from this point forward could determine whether the defendant stays free or goes back into custody. The pressure is already building.
We will handle the arraignment first. Well, Ms. Kelly, I have a bench warrant that alleges the following: that you are in violation of your bond for failing to submit to a test on November 25th of this year, that you failed to appear for drug tests as ordered between the November 25th and December 9th, that you failed to report a prescription, and that you tested positive for amphetamine and THC on November 25th through the 9th of December. And not part of the bench warrant, but we had you tested today, and you tested positive for amphetamine and THC. Back at arraignment on the 21st of November, the court had ordered no, among other things, no controlled substances, including recreational marijuana testing. You do have the right to have a contested hearing regarding that bond violation, where the prosecution would have to present evidence to determine whether or not you are in fact in violation of your bond conditions. Do you understand that?
I do.
Mr. Dick, how does your client wish to proceed regarding the bond violations?
Your Honor, for the purpose of the bond violations, she does want to accept responsibility.
Okay.
An explanation.
All right, and then I believe we also have a resolution on the underlying case. Is that accurate?
Yes, Your Honor.
And that would be?
Your Honor, the people have offered that if Ms. Kelly were to plead domestic violence, we would recommend that for a deferral.
Is that a guilty plea or a no contest plea?
It will be a no contest, Your Honor, due to alcohol consumption, I believe, with PBT.
Let's handle the bond violation first, because that could be determinative as whether or not I'm going to follow the recommendations of the 4A. So, Ms. Kelly, is it true that, as you were aware that as part of the bond conditions, you were supposed to test as ordered?
Yes, Your Honor.
And you were not to consume, I forgot to swear you in. Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. And that you were not to consume controlled substances, including marijuana. Did you understand that?
I did not fully understand that I was not allowed to use. I was under the impression it was recreational marijuana.
Do you have a card?
I do.
All right. Is it a valid card?
It is.
Did you provide that to community corrections?
I have not.
Why not?
I just figured, because I knew that I was going to come out positive for marijuana, and so I figured that I would provide it at this time. I haven't gotten an actual copy of my card. I did apply for it because I knew that with being on probation.
When did you apply?
The day after I was released from jail. I've had one in the past, but with marijuana becoming legalized, I didn't renew my card. And then once I was put on probation, then I renewed it.
Do you have proof with you today?
It's on my phone.
I have a copy of the approval, a picture on my computer.
Just what's the date of the approval?
The actual approval, the email shows that it was sent on December 3rd of this year. saying that she has been approved and she should receive her card within 7 to 10 business days. That this is a temporary substitute for the card and is only valid for 30 days from the date of receipt.
Does it indicate when the application was submitted?
It does not, Your Honor.
All right. Is it true that you failed to submit to a drug test on November 25th of this year? Or
What day was that?
That would have been a Tuesday. The Tuesday before Thanksgiving.
I don't think I had a receipt for that day because something happened to it. I've never missed a drug.
This is where the hearing takes a dramatic turn. Instead of simply accepting an explanation, the judge wants evidence, not excuses. In court, facts always carry more weight than stories, and when a judge orders an immediate hearing, it usually means patience is wearing thin.
I've never missed a drug test or an alcohol screening.
All right, I'm not going to take a plea. We're going to have a hearing on this. Ms. Dahl, are you prepared for a hearing?
I don't have the community corrections officer here.
She's right there in the back row.
Oh, I'm so sorry.
May I have a brief conversation with her about that?
No, we're going to have a hearing. We're going to have full of excuses, so we're going to have a hearing on this. Mr. Dick, do you need a moment to talk with her about a potential defense for the hearing?
I think just 2 seconds, Your Honor.
All right.
We just taken over this matter from the previous attorney who essentially quit his job yesterday.
Okay.
And this one particular date that you're asking about, we may be able to resolve that. I think there's a sufficient amount of shit within the rest of the bond violation if Burke would be willing to accept her responsibility to the rest of those. Or if that's not the case, I do ask that just afforded some time if not in contact with the testing facility to actually the action confirmation for that particular day.
All right, Ms. Matsky, let me ask you some questions because it's not entirely clear in the petitions. So the petitions say that the bond violations, so for example, the one dated December 5th says that the alleged bond violations occurred on November 25th through November 30th. So that's a 5-day gap. Can we narrow down those dates?
Maybe November 25th, November 28th, and November 30th specifically.
And then the one dated the 12th of this month alleges 11/25 through 12/9. So presumably that's going to be the 25th, 28th, 30th. And then are there some dates in December as well?
December 3rd, December 9th, 10th, 11th. As of now.
Those violations. So the only violations that the court had presented to us would have stopped then on, it looks like the 9th. Ms. Dahl, do you know, I see you signed this on the 12th, but you alleged violations through the 9th.
Yes, Your Honor. I did get additional violations since that time, but I have not submitted them to the court yet.
Okay.
I think the issue we're having with the defendant is she is testing downstate. She is testing late, not according to the procedures given to her. She has to test by a certain amount, by a certain time in the morning. She's testing in the evenings. She's not providing proof that she tested timely, and then the results come later. So she's not testing as directed. So she's not testing in the mornings when she's told to, and she's not providing proof.
So are we, so I want to make sure we're clear on this. It's not necessarily, so it is a fail to appear as ordered, but not that she didn't test, she just didn't test when she was supposed to.
Correct, and she's not providing proof of her testing at the time that she's.
Ms. Matsky, have you received proofs of these tests?
We have received results for most of them. I believe the violation started as a no-show because that's what it appeared to be as from our office, and then I believe we updated them as a late test. So it just gets a little bit murky when we're updating violations.
Okay. All right. So, Mr. Dick, does that, I'm not sure if that cleared the water or muddied the water.
I think, Your Honor, it clarified that what should be asked is whether she is going to accept responsibility or plead guilty to the fact that it wasn't as directed as opposed to not testing, which is, I believe, what was originally just asked.
All right. All right, we'll give it another shot. Before we do that, though, I need clarification then, Ms. Matsky, on what dates did she test positive on the 12th petition? It says positive for amphetamine and THC. Oh, hold it, I probably have it here. A second. So it looks like there was a alleged positive test on the 30th.
Notice how the judge carefully breaks down each alleged violation one by one. That isn't just routine. It's about creating a clear legal record. Every admission matters, and even small inconsistencies can completely change how the court views someone's credibility.
All right, so we'll try this again. Then, Ms. Kelly, is it true that you failed to submit to a timely test on the 25th of November?
Yes.
Pursuant to the rules.
It is, Your Honor.
And how was it not timely?
Because it states on the forms here that I have to test between Monday through Friday is from 11 a.m. till 10 a.m. I was under the impression that that was for PBTs, not ETGs, because I was under the assumption that ETGs, the alcohol stayed in your system for at least 24 hours. And I started taking ETGs daily once my machine broke. And they said not to return the machine, like not to send it back, because if it were to get lost in the mail, it does cost $1,200 to return it. I called this facility the day that I told them that it was broken, because when I blew into it, the little code came back and it said test, like, it said something, it said a weird error that
So let's cut to the quick. Did you not test within the time frame allowed that day?
Yes.
All right. Did you submit proof of testing for that day to Community Corrections?
I believe I did. What I do is when I submit proof. Yes,
You submitted proof of that
I believe so, I did,
that day?
that day.
On the 28th of November, did you also then test positive on the 25th for amphetamines and THC?
I'm sorry, what was that?
On the 25th, did you test positive for amphetamines and
Yes, Your
THC? And on that date, did you have a prescription for either of those?
Don't believe I did.
All right. Had you provided it? So if you don't believe you did, you would not have provided a prescription to community corrections.
I did not provide my prescriptions to community corrections. You are correct.
On the 28th, did you test within the requirements?
I tested late.
All right. And did you test positive for amphetamines and THC that day?
I did.
And did you have a prescription for either of those?
No.
On the 30th, did you test outside of the testing parameters?
Yes.
And did you also test positive for THC and amphetamine that day?
Yes.
Did you have a prescription for either of those?
No.
On the 3rd of December, did you test outside of the testing time periods?
Yes.
Ms. Matsky, you said amphetamine was negative that day. Was there a positive THC that day?
Correct.
Did you test positive for THC that day?
Yes.
And did you have a prescription on that day?
Yes.
I'll refresh my memory. When was that approved, Mr. Dick?
The 3rd, Your Honor.
You had not provided that to community corrections.
You're correct.
On the 9th, did you test outside of the testing requirements?
Yes, Your Honor.
You tested positive for amphetamine?
Yes, Your Honor.
And did you have a prescription for amphetamine on that day?
No.
Ms. Matsky, was that also a positive THC?
On the 9th,
Yes.
yes.
On the 9th, had you provided your prescription for THC to community corrections?
I did not, Your Honor.
Do counsel believe defendants provided a factual basis to accept the plea to the bond violations?
Yes, Your Honor.
Yes, Your Honor. And just as a formality, I'm not saying she is accepted. I don't see where I have a December 3rd retest on here. However, I do acknowledge that she. Forgive me, I did take over this.
Yeah, so on the violation marked, or that Ms. Dull dated on the 12th, that's 11/25 through 12/9 are the violation dates.
Okay.
And those are the dates I went through with Ms. Matsky. Ms. Matsky, you did say the 3rd was one of those that she had missed, or that was late.
I'm not,
Did I write it down
yes,
wrong?
it was at 5:10 p.m.
On the 3rd,
Yes.
okay. All right, the court does find that there's sufficient evidence to find the defendant in violation of the bond conditions. Counsel, I'm going to tell you right now, her performance on bond, I'm not going to go 4A with her. If she can't perform on bond, there's no way she's going to convince me that she's going to perform on probation. So,
Your Honor, may I speak?
May.
I'm recommending that Ms. Kelly be remanded today regarding the bond violation, and I would ask that the court accept her plea, but refer her to get a PSI in this case. I believe the history behind her alcohol use that led up to the crazy events that happened that resulted in these charges is something that the court should consider and potentially may not know without a PSI. So I think with a PSI, the court potentially might consider a deferral, but we would ask the court to at least refer her to get
Now the courtroom shifts from violations to personal history. The defense is asking the judge to see the person behind the case, not just the mistakes. But here's the question. Should personal tragedy reduce legal consequences, or should the rules apply exactly the same to everyone?
For her to get a PSI so the court may have more background information as to why the people recommended the deferral.
Well, why don't you tell me why you're recommending the deferral?
Well, I don't know if she's okay with sharing it, is in the police report. She lost her son about a year ago, and she did not deal with that well. And she resulted, from what the police report says, she turned to drinking as a way to cope with her pain. And that resulted in the actions in this case. I'm not in any way condoning her behavior while on bond, and it was a continuous violation after continuous violation after continuous violation after continuous excuses from her. I do want to highlight that she did test every time she was supposed to, even though not on the terms that she was required to. So I believe that she has the potential to abide by probation terms. I think that her background and with services, she might be able to be a good candidate for probation. So that's why the people are recommending a deferral in this case.
Mr. Dick?
Yes, Your Honor. So as it pertains to the deferral, we are asking that the court would accept that, or would extend that. This, as mentioned, there is more background that we can provide to the court, stemming all the way back from the loss of husband in 2013 to a suicide, Your Honor, which we haven't yet, you haven't yet taken the plea on the domestic violence charge. But all of this plays a part in what has been going on to this time, as well as the other attorney that was handling this matter has not been in contact with her about this to really figure things out. And some of the issues here, I believe, are either a lack of advice from the prior attorney or a lack of good advice. In this matter, Your Honor, as the prosecution said, she has tested what she's required to, although not within the parameters. One of the things that I'm going to specifically mention is the fact that she did have a breath machine that she was testing on, and she was testing properly initially during her windows that she was provided. It was after that, when she was doing the ETG test, that she tested in the afternoon. One thing that I can attest to the court about the providing the test to the court, I've practiced downstate for most of my career so far. The facilities generally do not give the testing reports or anything to clients, or much of anything. The receipts are provided in case the report isn't provided to show that they actually showed up.
Right.
And
Which is why community corrections request the receipts be provided.
I understand that. I understand that. And I think part of the issue here is with everything going on, Ms. Kelly having her substance abuse issues since the loss of her son. She did have a quite a span of being sober. However, having PTSD issues from her husband's death and having her son pass away here suddenly this past year, there's a lot of mental health issues that have arose, and dealing with it through substance abuse has been really the only way that she found she was able to get lost. So she's been alcohol-free since this domestic violence incident. She's not tested positive for alcohol, I'm aware. She may have some other issues that she's been dealing with that she definitely needs, and stated that she needs the accountability to get through this. She also tried to schedule a appointment recently to get into some sort of counseling to deal with everything. She hasn't been sober since her son's passing. This time period right here is the first time that she's been able to get her mind at all focused on where she needs to go in life since then. With that being said, Your Honor, we are asking that she gets a second chance, fully knowing that if she violates any terms of bond or probation, that she could end up right back here in jail serving the ultimately full sentence for the underlying charge or contempt of court. That being said, Your Honor, Ms. Kelly came here today knowing that she was potentially facing jail, just based on the bench warrant and the allegations from the bond violations. But she still showed up here today. Now, she lives downstate. She lives in Roanoke, and it is a bit of a feat to get up here. However, if the court would extend her the deferral, keep her on probation for a period, which she actually is welcome to be able to have some more accountability in her life, to get herself clean, to maintain her sobriety, and to make sure that she's getting the mental help and treatment that she requires to avoid any further substance abuse issues, pardon me. And with that, Your Honor, we are asking that the court declines to remand her today and perhaps give her one additional chance. And as I said, she showed up here today knowing she may end up in jail. So do not believe that there's any issues with her not coming back.
This is the moment everyone has been waiting for. Despite hearing emotional arguments from both sides, the judge makes it clear that repeated violations have consequences. In the justice system, accountability often outweighs promises about what someone will do in the future.
Coming back to court.
All right, thank you. I'm not going to take the plea today, but I will order a PSI because I don't want to. If I take the plea and I don't follow the agreement, she's going to be given the opportunity to withdraw. So we won't do that yet, but I will order the PSI. In regards to bond, I have somebody, yes, who is not testing positive for alcohol, but they're testing positive for other substances that, at least in the beginning, they didn't have a prescription for. The court's not impressed that once it was ordered, she ran out and then got approval to use THC. But she also doesn't have a prescription for amphetamines. She didn't, even when she got approval, she didn't provide community corrections with the prescription for THC, her medical marijuana card, nor has there been any prescription provided for the amphetamine. Bench warrants have been floating around on this case since November 26th. So the fact that she presented herself today, knowing that there was a bench warrant, presumably knowing what was a bench warrant, the court's not impressed with that either, because for about 2 weeks she must have known and then just didn't do anything about it. As far as a second chance, she had that chance on the 28th when she tested outside of the requirements. She 30th, the 3rd, the 9th, and then not presented to the court, but Ms. Matsky gave 3 more dates. I've got somebody, it does no good for me to order bond conditions if I'm not willing to enforce them. And so I am going to remand the defendant to the custody of the Wexford County Jail, and we'll get the case reset. Anything else for the record?
No, Your Honor.
The hearing ends with a powerful reminder that court orders aren't optional. They're legally binding. One missed requirement can snowball into much bigger consequences. What do you think? Did the judge make the right decision? Or should the defendant have been given one more chance?
All right, ma'am, you'll have to go with the bailiff.
Personally, I think this hearing shows that every decision we make has consequences, especially when we ignore the law or fail to take responsibility. Throughout this case, the judge wasn't just focused on punishment. He was trying to make the defendants understand how today's choices can shape the rest of their lives. Whether it's missing court, breaking the law, or making reckless decisions, those mistakes can quickly spiral into much bigger problems. Hopefully, this serves as a reminder that respecting